Okay, good afternoon, everyone. Can I have your attention? Thank you. Welcome, everybody, to the 24th Annual Saskatchewan Law Review Lecture. My name is Morin Phillipson, and I'm the Dean of the College of Law, and I also wear another hat in that I'm the faculty editor of the Saskatchewan Law Review. As we get, thank you, Priscilla. Checks in the mail. As we gather here today, we acknowledge we're on Treaty 6 territory and the homeland of the Métis, and we pay our respect to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. The Saskatchewan Law Review Lecture is part of the McKercher Lecture Series at the College of Law, and so on behalf of McKercher LLB, Lorne Fagnan of the class of 2016 is here to say a few words. Lorne.
Gotta grab my speech here. Thank you, Dean Phillipson. Thanks to everybody for being here. Chief Justice Popescu, Judge Morin, other members of the judiciary that I do see around, other faculty. As a former student of the college, kind of exciting to be back here. Never really thought I'd be standing here, but still kind of nice. The lecture series is pretty important. Attended a few of these throughout law school. Gives you a unique opportunity, obviously, to engage and hear from experts in various areas of the law. Judge Morin is certainly no exception to that. It's important for us at McKercher LLP to be part of this, so I do thank you guys for having us here today to support this important initiative, and look forward to hearing what Judge Morin has to say.
Thank you, Lorne. I now want to introduce three very important people at the Law Review, the managing editors of the Law Review. In no particular order, Eric Turcotte, Sophia Lajamodiere, and Megan Ripplinger. And how this is going to work, I'm going to invite Megan and Eric up to introduce our speaker, and then Sophia will say words of thanks at the end.
The Saskatchewan Law Review is delivered annually by a distinguished speaker on an important topic in law. The lecture is published in the Law Review, which is published semi-annually by the College of Law under the authority of the University of Saskatchewan. Law students at the University of Saskatchewan get hands-on experience editing a legal journal when they are selected for the student editorial board of the Saskatchewan Law Review. The editorial board comprises 18 second and third year students. Students on the editorial board select and edit articles for publication, set policy, and must write a paper for possible publication in the review. In the process, these students learn about legal publishing and can improve their legal research and writing skills.
Today, we are very pleased to have the Honorable Judge Gerald Morin, King's Counsel, Order of Canada, and former Provincial Court Judge. Judge Morin was born and raised in Cumberland House, northern Saskatchewan, and is a member of Peter Ballantine Cree Nation. After starting out in the criminal justice system as a probation officer in 1973, Morin was determined to follow his dream of becoming a lawyer and earned his law degree from the University of Saskatchewan in 1987. After graduating, he began practicing law in Prince Albert with Pandilla Morin Law Office, and during this time, he appeared at all levels of court, including the Supreme Court of Canada. In 2001, Judge Morin was appointed to the Provincial Court of Saskatchewan until he retired in 2019. Morin helped pave the way for the Cree-speaking provincial court system during his years as a judge, sitting in Indigenous communities such as Sandy Bay, Whitefish First Nation, and Atakakoop First Nation. In January 2023, Morin was appointed as an officer of the Order of Canada for his groundbreaking contributions to the Cree court circuit and for his mentorship of the next generation of lawyers and judges. Welcome, Judge Morin.
Usually I don't need a mic, but maybe today I do. I might lose my voice. Tansen do timitik. Nanaskumon, utano tse pepikskrian. Umota Good afternoon. Elder Joe Natauhau, Chief Justice Popskill, Dean Phillipson, and special guests. I'm very honored to be here today because I'm also very glad that Dean Martin Phillipson finally found my letter from the then Dean Danish inviting me to the law review back in my second year, 1985-86. It is my understanding that students with high marks are invited by the Dean of Law to this prestigious law review. I'm led to believe that just because you're invited by the Dean does not save you a spot. There are other criteria to make it to the law review. For the students who might not be able to relate, this was prior to the days of usage of emails, and therefore it was very easy to lose letters. It's better late than never. I'm only too happy to oblige. But if the truth be known, and it should always be, I was one of the people that the late Stu Eisner would often refer to as my friend with no distinction, yet here I am. Let me comment just a bit on the recent award of the Officer Order of Canada. These type of journeys are never traveled alone, and I have many to thank, especially my own family, my wife Sherry, and I think my son Dan is here. Yeah, he's here. I think of my late parents and my late sister, all of whom played a major role in my success. The Cree Court clerks, Carla Swan, she's now a manager in the Laurence Provincial Court. Robert McCollum, who's now a senior clerk and still doing Cree Court in Prince Albert. Olive Cook, who's now a senior clerk in Lloydminster. I traveled with this crew for 18 years on the same circuit, 3 weeks of every month. It was a tough circuit. It was tough in terms of just the travel itself. And I remember the now retired Don Bird and legal aid lawyer Angus McLean. I make special mention also to Fran Atkinson, KC, because she worked a lot of years in the Cree Court. Numerous others I've not mentioned. But let me get to my message. It's titled, Beyond Gladue, Truth and Reconciliation. I hope I can get through it all in 50 minutes. I never thought I would be in a situation where I worked so hard for the last 2 months. I thought I was in final exams for law school. And I know how much I hated this place during that period of time. So I didn't get that feeling this morning when I drove up. But certainly I know the students probably are starting to feel a bit of the crunch, but you'll get through. What I want to do today, a bit, since it's a law review, what area of law do I want to look at? I want to look at one specific area of law in terms of how we apply Gladue factors. And in doing that, I look at certain remarks made by Court of Appeal, but I will infuse there points of observation from the Cree perspective. By that I mean, throughout my years in being a judge, how I often looked at that when I was thinking of, who is this person standing in front of me? And where does he come from? It might mean mere simple words, but it is more than that. First of all, you're doing it with a human being. There's human factors and the frailties that come with it, along with yours. Where do we go from here? I might not get there, but I will certainly mention certain factors. We've only just begun to cut out a pathway for lawyers representing Indigenous students to follow when they embark on their presentation about Gladue, on how their clients diminished moral culpability should be analyzed. Too often, we merely hear that the lawyers know their clients have attended residential school or they're the product of the 60s scoop. There's so much more than that in terms of who comes before you. They list a number of factors, but come short of analyzing the impact of those life events that are now playing out in this person's life. In order to properly analyze the matter and the manner in which to apply Gladue factors, there's numerous cases one can look at. One that I looked at is Chenalquay, which was in 215 Saskatchewan Court of Appeal. I certainly looked at JP, which is another Supreme Court or Saskatchewan Court of Appeal, and R versus Charles also, which is originated out of L'Orange, the judges, and then ended up at the Court of Appeal. The decision in Chenalquay is a case involving an accused who was a member of Buffalo River Dene Nation. The accused was convicted of sexual assault after having sexual intercourse with a woman who had fallen asleep during the course of a party. In sentencing, the trial judge gave significant weight to various Gladue factors and imposed a sentence of 2 years less a day. The Crown appealed, and the appeal was allowed. In most starting points, you will certainly look at cases that say maybe the starting point, if there is such a thing, would be R versus Wells, or different cases. 3 years would be mostly a starting point. This started at 2 years. The Court of Appeal, in allowing the appeal, looked at it, did not add time to the time in jail, but they added a component of 18 months for probation to look at ways that this person can go through and try and work at rehabilitation after time in jail. The important thing in this case is that Chief Justice Richards clarified that when sentencing judges are applying Gladue factors, it is necessary to first examine both the nature of the relevant factors and the particulars of the crime in issue. Then the sentencing judge should consider the extent to which unique circumstances of the offender based on their culpability in the specific context of the case at hand. Also, sentencing judges must attempt to give meaningful effect to Section 718(2)(e) and be cognizant to the ongoing problem represented by the troubling incarceration rates of Indigenous people. Section 718(2)(e) outlines and directs a sentencing report that all reasonable sanctions other than imprisonment, which are reasonable in circumstances and consistent with the harm done to the victim or the community, should be considered for all offenders, with particular attention to the circumstances of Indigenous Aboriginal offenders is the wording that's used there. If you look at the history in terms of how laws have reformed over the years, you would need to look back on this particular wording and see where else it arises. It actually comes from a Quimet Law Commission 1969, which used similar language in its report. It states, amongst other things, separate the dangerous data and restrain the rationally motivated professional criminal, deal as constructively as possible with every offender as the circumstances of the case permit, release the harmless, imprison the casual offender not committed to a criminal career, only when there is no other disposition appropriate. This might properly be based on the principle of restraint in the use of imprisonment of all offenders. The 1969 Quimet Commission was a report, but Section 718(2)(e) is in the Criminal Code. It's codified. There's a major difference between a report when people can put it aside, but when you walk in with a criminal code and that section's in there, it needs to be looked at. It needs to be analyzed. Drawing on the Royal Commission on Aboriginal Peoples, as well as several academics, in looking at the case Gladue, Justice Corey and Akabuchi reviewed the history of Aboriginal Canadians in the criminal justice system. In their conclusion, it states, the problem of over-incarceration of Aboriginal people is the tip of the iceberg. In paragraph 61 of Gladue, it states, not surprisingly, the excessive imprisonment of Aboriginal people is only the tip of the iceberg insofar as the estrangement of Aboriginal people from the criminal justice system is concerned. Aboriginal people are overrepresented in virtually all aspects of the system. And they go on to say, as this court noted in R versus Williams, in 1998, 1 SCR 1128, paragraph 58, there's a widespread bias against Aboriginal people within Canada. And there is evidence racism has translated into systemic discrimination in the criminal justice field. Now, while I make these type of remarks in terms of Indigenous people, one thing I want you to keep in mind is that when I was sitting in court at any given time, I was probably dealing with 25 to 30% of the people in any given area. What does that tell you? That tells you 70% are doing excellent. If you look at it from that perspective, you gain a little bit better insight as to who you're dealing with. Don't forget that in terms of that, because the 30% makes the headlines. The other 70 very seldom make headlines. That's the way our world works, and sometimes we can't lose sight of it. The one thing about Gladue, of course, is that it took a long time for us judges to get it, okay? I think the proverbial slap on the head came when Ipili was released a number of years later. And that focused on proportionality, causal connection, application of Gladue to serious offenses. And in paragraph 17, Justice LaBelle stated, first, systemic and background factors may bear on the culpability to the offender. To the extent that they shed light on his or her level of moral blameworthiness, this perhaps more evident in Wells, where Akabuchi described circumstances as unique, systemic, or background factors that are mitigating in that they may have played a part in the Aboriginal offender's conduct. Wells at paragraph 38. Canadian criminal law is based on the premise that criminal liability only follows from voluntary conduct. Many Aboriginal offenders find themselves in situations of social and economic deprivation with a lack of opportunities and limited options for positive development. While this rarely, if ever, attains a level where one could probably say that their actions were not voluntary and therefore not deserving of criminal sanction, the reality is their constrained circumstances may diminish their moral culpability. The question of moral blameworthiness can be viewed through in Justice Richard's individualized approach in Chenalquay. As stated before, he points out and states it's not simply stacking up Gladue considerations at play. He stated very clearly, the required analysis is more demanding than that. To determine the extent to which Gladue factors impact on an offender's culpability, as mandated by the Supreme Court, the search is not for the cause and effect relationship, but for circumstances that cast light on the degree of the offender's blameworthiness for the specific offense in issue. It might be that Gladue considerations impact the offender's culpability a great deal, not at all, or only to some extent. I recently looked at a case where an individual pled guilty to once again driving while disqualified. He had an extensive record of 21 prior convictions related to driving while impaired, along with 2 dangerous driving considerations. From 1994 to 2016, or 2018, he had 6 impaired, 2 dangerous driving, and 13 driving while disqualified. Often regarded as serial offenders of drinking and driving, the court has often looked at incarceration and fairly long forms of incarceration. This individual, the PSR stated that this person was born to a big family of 11 siblings. But his mother died when he was only 6 months old. The family was separated into 2 homes within Red Earth Cree Nation. The girls, there was an even number, 6 girls, 6 boys. The girls went to live with their grandmother on their mom's side, and the boys went to their father's mother. This young man was not in conflict with the law right up to the time he turned 18. 2 events then occurred right at the crucial period of time. His grandmother took ill, and his brother next to him in age committed suicide. It's described in the PSR as follows. When Lionel was 17, 18, his grandmother took ill, and she was in the hospital for some time. And one day his brother took him over to his aunt's place and told him to stay there, and I'll be back to pick you up, and we can go back home. His older brother never made it back. He had committed suicide. The PSR stated that Lionel had, and I'm talking about the time back then would have been 1994-95, and this PSR was just done last fall. He still has a very difficult time dealing with his brother's suicide. He still gets emotional when he talks about it, and he had to move out of his grandmother's home as she was no longer in a position to look after him. He started drinking in a big way, and he amassed 12 convictions within a 2-year period, composed of 2 over 08, 1 impaired, 2 dangerous driving, and 3 driving while disqualified. That's a major shift in how a person's looking at things. He also had failure to appear, mischief, and 1 breach of probation. If he is still emotional today about his brother never returning to pick him up, how do you suppose he reacted during the time of the suicide? It is clearly reflected in his efforts to drown out his pain and self-medicate by abusing alcohol. He went on a blind alcohol binge for about 2 years. And that 2-year period, and having amassed that type of record, what did he try to do to alleviate or mitigate his spiral into oblivion? The PSR indicates he took his first attempt at quitting his alcohol binge. And he first took alcohol treatment in 1995. It's during that 2-year period. He's feeling that he's really taken the wrong path. He does not get any driving charges of any sort till he gets 2 DWI, or driving while disqualified, in 1998. In 2001, he again seeks alcohol rehabilitation after unrelated convictions of obstruction, peace officer, causes disturbance, failed to comply with the probation order. Although when I looked at the record and compared what was he on probation for, I couldn't find any probation order. So sometimes those reports it's only as good as the input. They might have missed something, or they might have made a mistake. In 2002, he gets 3 more driving while disqualified, but no impaired or any other conviction until 2006. In 2006, he goes back to drinking. He was sober through that period of time, and within a 2-month period, he gets convicted with 2 impaired driving, along with 1 dangerous driving, and 2 more driving while disqualified. He again tries to mitigate his circumstances and takes alcohol treatment. And for 5 years, until April 2012, he has no criminal convictions, the longest gap in his life. He gets another driving while disqualified in 2012. He gets 18 months jail, plus a 3-year driving prohibition. That same year, at a New Year's Eve function, his daughter makes a request to her father. She says, "Quit drinking, Dad." This has some impact, and he remains sober until 2015, when he is again charged with impaired driving and driving while disqualified, and he pled guilty in 2016. He received another 18 months jail, plus 5-year driving prohibition. Note that this was his last impaired. So when he got charged the last one, you're looking at, he gets charged in 2021 of this particular case. He did get 1 more in 2018, driving while disqualified, but no impaired, and he got 2 years jail on that particular occasion, plus a 5-year suspension. Now, he comes before me in 2021. In 2022, I started with the case last fall. What should be the proper sentence? What should I look at with respect to this individual? The Crown asked for 3 years penitentiary, and plus a 10-year driving prohibition consecutive to what he has now. When I looked at all the sections and everything about his driving records, right up to the day of that time, he would have, from where I can figure, he's probably got a driving prohibition till 2023, 24. I'm not sure, okay? But that's what I figured it was. Defense asked for a 2-year conditional sentence plus 1 year probation. It was at that point I started asking questions, because clearly I did not see a foundation for a meaningful community-based sentence, and I was also being asked to send someone 3 years in the penitentiary for driving while disqualified. Like I said, his last impaired was 2015. I first focused on the offender. I asked him questions in Cree. I asked him why he was driving, and he answered. I asked, he agreed he was not listening to the driving prohibition, because I asked him, are you hard of listening? Are you hard of hearing? What is it that makes you still drive? It's not as simple as that, but that's a literal translation. And he said, he replied, because I looked at the wording, okay? I looked at the wording and said, because the wording was precise in how I asked the question. Because if he was just jealous of others driving or didn't care, he would have used eutenitaman, eutenimak. I'm jealous of somebody. But no, he responded ega watamagian, which I took to mean he covets something and the privilege of others who can drive and he can't. Then I asked him questions about SGI programming, on how to get his license back. He said in Cree, "Gi wapatanigok tapiche putachigian pek mamongo chigaskinian egauchi at tuskenean." He said in Cree, they told me about a machine they could put on, but I would have to pay for it. I did not have a job, so he intimated from the statement he could not afford it. In the report, he now has a job. We can never underestimate the full effect of how demoralizing poverty is. It limits all aspects of your life: housing, mobility, quality, even quantity of food. I then asked the defense if they could provide information as to what are the possibilities were of the offender to get his license back by working with SGI. Because I had nothing meaningful, I had to push back and get legal aid in this situation to say, go find out what this is about. They submitted the following information: an impaired driving pamphlet outlining some relevant information. It specified, if you do not complete the program within a specified suspended time, meaning the court-ordered suspension, and if you don't do any programming, your license will continue to be suspended. There are startup costs of $170, plus travel costs to a location determined by SGI, $450 a one-time cost for programming. That already totals $620. Installation costs for the machine of $155. Monthly lease costs for the machine, $77. Unlock system code, $83. Lease protection per month. I found this interesting. But lease protection, $13. So if there's any damage, there's some insurance for it. Or you could pay, if you could afford it, $100 and save yourself a couple of months. Service call if the unit needed to be reset if it registered a fail. Because what you do is you're getting in this vehicle, you blow into a machine, and if it registers a fail, it locks your vehicle. In order to reset it, you then have to get a service call, and it costs $105 for the service call and 60 cents per kilometer. I tried to figure out where's the nearest place that he had to do this. There was also additional costs, 30 to 60 days, and you must make an appointment at the interlock facility so they can service the device and download records of how many times you would have broken the law in trying to get into a vehicle. In addition, a person has to take a 16-week alcohol counseling program at the SGI office where it might be available. The cost associated with this portion of the program depends upon their individualized assessment and the length of time they were told they were required. I was always the impression that it was 16 weeks because in Cree Court, what we instituted in two places, at Takakoop and Whitefish, is where I saw a lot of people having driving while disqualified. Of course, somebody made the wise decision of stopping STC buses around this neighborhood, so it became a bit of a problem. The other thing that a person would have to do is take driving without impairment program over one weekend at a location determined by SGI, an additional cost of $150 for the weekend. Accommodation. When I looked at the information, it looks like the nearest place that a person could take the program would have been Melfort. For this person, it would mean driving back and forth and the distance between Red Earth and Melfort round trip is 360 kilometers. As stated in SGI materials, if you do not finish any sanctioned program, your license would be subject to the administration suspension. This person had been suspended already for 28 years, 10 months. Now, notwithstanding that the court-ordered suspensions only totaled 17 years, which means he was subject to a further 11 years in administrative suspensions from SGI, and he had basically given up the possibility of ever being able to drive again legally. The question that arose, of course, how does the court characterize the SGI interlock program? When looking at the financial commitments that one has to make in order to get their license back, how accessible is it if you have limited income or you're on social assistance? It can be argued that it was never meant only for people who could afford it, or the other possible conclusion, SGI interlock system morphed into a systemic discrimination situation against poor people. I realize that many who look at drinking and driving, and it is a major problem, don't get me wrong, it's a major problem. I looked at different material, and Mr. Justice Sinclair, who was also a co-chair in the Manitoba Inquiry back in 1988, as he then was asked about the question of systemic discrimination. He says, let me explain it to you this way. If you get rid of all the racists in a position of government, policing, justice, health, you will still have a problem because you will have a system that is functioning based on policies, priorities, and decisions that direct things, things and how they're done that come from the time when racism was very blatant. Some people will say those are harsh words, but sometimes reality dictates different. It's the impact on people that is important, and to understand how that impacts them. The costs associated with SGI interlock system is this programming based on today's dollars. When sentencing an Aboriginal offender, the court must take judicial notice of systemic and background factors in addition to individual circumstances. How should the court look at this situation? In the Cree world view, particular to each community, there are concepts based on elders' teachings as to how one might better understand where this person is coming from with respect to his actions. These teachings illustrate a different method of analysis in looking at an individual. I used the words earlier in my own description. I said, it's a sipitak, one who doesn't listen to his parents, teachers, court orders, probation orders. He's got his own drummer. He's going to go to that beat for a while. Hikakipatsit, one who makes a major mistake or minor mistake but does not reflect a pattern of behavior. Yigitimaksit, this is the one that I looked at. One who has impoverished social skills, including alcohol and drug addictions, rooted in unsolved issues of anger management, grief, trauma, or victimization. Imatsatsit, the evil one, who does severe harm in his actions or words. We don't get many of those. In fact, if I really looked hard, I don't know if I'd get past my first hand of the true evil ones that come before you in court. But many of our laws are made based on the action of the evil one. the ones that draw carnage, major issues, and cause problems. And when I say, don't get me wrong, that I don't look at drinking and driving as serious, I do. I've seen the other side of the carnage in relation to dealing with things in court where impaired driving causing bodily harm, or a young man picks up his girlfriend, he has no criminal record, he gets in a major car accident, she's now a quadriplegic, and he's walking. He pleads guilty to it. I dealt with a young man like that. There's nothing more painful than to hear the mother of the young woman who can no longer walk. That's the other side of that. So you've got to keep that in perspective of when you're dealing with these type of situations. You don't deal on the basis of pity. You deal on the basis of trying to understand who is in front of you. These concepts can be used in describing an individual in Cree, but throughout the discussion of the person and where he's at, one can use further descriptions which clearly delineate a more precise understanding of who you're dealing with. Who am I dealing with in this situation? Here he said, I could not pay because I did not have a job. He was opening up his feelings of humiliation brought on by his lot in life, unemployed and broke. And I say, as I just mentioned, the court knows the carnage that impaired drivers have caused, and will this sentence be a sentence that is demonstrably unfit? Because that's what you got to think of. Is this a sentence you want to put out there that goes away from what the norm is in looking at impaired driving? Section 320.12 shows the recognition and declaration. It is recognized and declared operating a conveyance is a privilege that is subject to certain limits in the interests of public safety that include licensing, the observance of rules, and sobriety. The protection of society is well served by deterring persons from operating conveyances dangerously or while their ability to operate them is impaired by alcohol or drug, because that conduct poses a threat to the life, health, safety of Canadians. So, I ask, what if the rationale for protection of the public is not on the table? Here, that would be impaired driving. We have a driver without the right to a license. Some would say rightly so. But does this abeyance of the real problem or risk factor allow for a restorative approach? His last impaired is 2015 is when he gets charged. 7 years down the road is when we're dealing with, because we're still early in 2023. He has shown some redeemable efforts in achieving sobriety, but he erroneously concluded and gave up believing there was no hope in ever getting a license. When his last one was 2015, previous to that it was 2007. When you look at it, a sentencing judge's assessment of the offender's degree of moral culpability is an integral aspect of many key components of the sentencing process. It also directly implicates the proportionality assessment. An offender's degree of responsibility has implications as to how the principles of deterrence and denunciation are applied in any given case. It also informs the parity principle because the principle is grounded in a comparison of other sentences imposed on offenders with the same degree of responsibility for similar offenses committed in similar circumstances. It affects the type of sentence that is imposed. As Justice Wagner, as he then was, wrote in R versus Lacasse, everything depends on the gravity of the offense, the offender's degree of responsibility, and the specific circumstances of each case. There is no doubt in my mind, if he was convicted with yet another impaired plus the driving while disqualified, we wouldn't be here discussing this case. I would have done the sentencing, looked at the parity, and that danger would still be there and the risk would still be there. I'd have to make the tough decision of what I would have given him in jail. As in JP, which is a 2020 Saskatchewan Court of Appeal decision, original sentence in that one was about a case in dealing with global sentence for 2 robberies was 7 years consecutive to each other, and a BNE offense of 12 months consecutive to 2 robberies. The Court of Appeal reduced the robberies to 5 years concurrent, and as a result, overall sentence was reduced to 8 years. There was FASD involved, and the way the sentencing judge looked at was to look at it simply from Gladue factors, but not clearly analyze the impact of FASD in that situation and how it diminished his moral culpability. So when you talk parity, you don't look only in terms of what they got, but why things might have been reduced. When in the Cree Court, we learned in the mediation restorative approach we instituted in Attack-Cope Whitefish for driving while disqualified, is that SGI was willing to accommodate those who previously lost hope of getting a license. We learned that in the Cree Court. Yes, it's demanding, but when it involves an earned privilege with some possible windfall, we should encourage a beacon of hope, because if we take away hope in people, they become a danger to themselves and the rest of us. I remember quite clearly in a 2-year period in one of the communities I went to, there was 8 suicides within a 2-year period. The impact of that type of behavior by others on the young people was major. It had a domino effect in that community within a 2-year period, and to find how many young people committed suicide. So when I kept looking and trying to understand this person, was this a case where a restorative approach and giving a person some hope in getting something back, which is a privilege, is it worth it in this situation? That's what I had to grapple with. Again, I always reminded myself of different cases where I would see the carnage of impaired driving. This was not impaired driving. This was driving while disqualified. The risk factor was removed. Is there room for looking at a different approach? I know that in some cases the court has said it is one of those type of offenses to where serial drinking drivers driving while disqualified will be dealt with harshly. Well, is harshly always the only goal? Is there a way that this person can again come back? When I was doing the things in Attack-Cope and Whitefish, being readily identified who I was, even if I didn't wear a suit, people would know me, people from Whitefish. I remember 2 occasions when, in one case, a young man and just outside a store said, "Judge Morin," and they always referred to me as Judge Morin. And he came up and he says, "I have my license. You gave me my license back." And I said, "I didn't give it to you back. I probably wouldn't have," I said. And he laughed. And he said, "No, I got my license. I now have 2 jobs. I'm a taxi driver and I'm a bus driver." He was one of those serial drivers. Another one, when I went back just last summer to Whitefish. He was working as a security person, and the first thing he showed me was his driver's license that he got back. So there is hope for some people. People will take that next step. If I was to put this guy in 3 years in the penitentiary, another 10-year driving prohibition, what would I have achieved? Worst off, what would he have achieved in 3 years sitting in there? So it makes you think to look at alternative ways, not only in analyzing of who the person is in front of you, and what the goal is in sentencing. You can incorporate different things into a sentencing process based on who the person is in front of you. If he's Indigenous, you look at Indigenous perspectives as to truly learn who's in front of you. Use that, but still always keep in mind the balance that you have to. Because I keep repeating it, because it needs to be repeated. The carnage on the other side of it. We've seen all the horrible shows of 4 people killed, whatnot. I understand that. As in Delgamuuk, and in an article written by Chief Justice Lance S.G., The Duty to Learn, and he was writing for the Duty to Learn for judges. He discusses how the courts have held in Delgamuuk in its determination of legal source of nature of Aboriginal title. And the SCC had held the source of Aboriginal title evidence related Aboriginal perspectives on land, paragraph 3. He goes further and says it's grounded in common law. The point he was making, it's important to remember the Aboriginal perspective, and accordingly, Aboriginal legal principles must be taken in account in many areas of existing Canadian law. These include, for example, Aboriginal perspectives on family law, criminal law, and sentencing. Yes, that case had to do with natural resource law and land titles, but there is a duty on all judges to learn the other perspective. And some might say, how am I going to learn Cree? Well, there were only simple questions in that particular one. I'm sure we can talk about how you might look at it. But I think the point that I try and make is that if we keep putting people in jail with no hope, there will really be no hope. Like I said, we already have a great percentage that are doing fantastic. And we ought to keep moving that figure up instead of down. It's 5-1. I'm going to end there. I'm leaving a good portion of what I wanted to talk about for other things, maybe for another day, in terms of where do we go in the future. I'll just say, let's face it, we're all in here to stay. And that means we need to look after each other. We need to understand each other. And don't hesitate to look at the man in the dock. Thank you.
On behalf of the editorial board of the Saskatchewan Law Review and the rest of the guests here today, thank you for sharing your insights on this very important topic. I feel honored to be here today to hear you speak and hope to bring your words with me as I start to article. We would like to present you a gift to show our gratitude. Thank you.